We got Buddy McDuffie with a silencer question. With silencers becoming more and more popular and legal for hunting in many locations, do you think the latest SCOTUS ruling could eventually bring changes to the NFA? And this is another good question. People I think are asking a lot. I've seen a couple people implying that basically like the NFA, the Gun Control Act, the Brady Bill are all going to be in trouble now because of Bruin. And that's another area where I just think that's probably not the case.
Right.
Because of what Heller says.
Yeah, exactly. I was going to say the dangerous and unusual weapons portion of that decision, you could very easily see a judge say, hey, look, they said that this is presumptively constitutional, that there's a tradition of prohibiting dangerous and unusual weapons. And in our opinion, those regulated under the National Firearms Act are, dangerous and unusual weapons. So,
yeah. Now, here's the only thing I would say about that to the other direction. Heller was a compromise ruling. That's what it was. Like they needed to get Kennedy on board.
Yeah. And
so Heller was very specifically tailored to say one thing, which is that if the Second Amendment means anything at all, which they think it does, it means that you can have the most popular gun in the country in your own home for self-defense. And so DC's handgun ban was unconstitutional because of that. And so what it was trying to do is set up this baseline of what the right means without implicating a bunch of current law. And so they wrote these two paragraphs in there. There's a couple paragraphs. It's like 2 pages in the Heller ruling that basically say, all these federal laws that exist, all these federal gun control laws, they're all fine. It talks about being able to ban M16s, fully automatic weapons, being able to, ban dangerous because they're dangerous and unusual, I guess would be the logic there. And then being able to, keep dangerous people from owning firearms. So the background check system would be part of that. Now, maybe the court will start to chip away at some of those laws down the line. It's when they get into more detail on what exactly, it means to prohibit a dangerous person. Like how, for instance, I think you could see something like nonviolent felonies or somebody who's been convicted of a nonviolent felony being prohibited might conflict with this idea of regulating, keeping dangerous people from owning guns because, if you committed insider trading, does that mean you're too dangerous to own a firearm? Is that kind of person the kind of person that was being prohibited during the founding era, or is that too broad? Again, dangerous and unusual weapons. That's of course the common use standard is very flaky in and of itself, right? Like what the heck is common use?
Right.
Certainly for some things it's easy. AR-15s. They're the most popular rifle in the country, or even just base level Heller, right? Handguns. Handguns are the most popular category of gun in the country.
Right.
And so, it's pretty easy to tell that they're in common use. Machine guns, fully automatic weapons. Well, there's several 100,000 of them that are registered in the NFA.
Right.
Is that common? I don't,
or even silencers. There's millions registered in the NFA.
That's right. Yeah. So, I would still expect that those challenges are down the line challenges. You got a lot more things that would be immediately imperiled than the federal gun laws, honestly.
Yeah.
Maybe down the line, and maybe you're talking years down the line, I would think.
Yeah, I agree.
You can't know for sure, but that's where I would come down on it.